Yeah, hello everybody. Good evening. Are you able to hear me?
Yes, sir, we can hear
Yeah.
you.
Good evening. Acha. Ready with your barracks? What topic did we discuss yesterday? Framing of the issues, leading of the evidence, isn't it?
Yes, sir.
Under Order 14, Rule CPC, issues were framed by the court. uh, then witness you witnesses were examined, invoking Order 16. Then under the provisions of Order 18. The
Yes, sir.
hearing starts, the cross examination, re-examination. Order 18 rule 4 के अंदर you file the affidavit and the re-examination procedure under the Indian Evidence Act. Now it is भारतीय क्या नाम है अधीन साक्षी अधिनियम के अंदर होएगा उसके अंदर. That is relevant sections for section 137. Give me that new act also. So probably in the university you will be having a new acts. Remember that it is now made clear from today itself. The Bar Council, the CRPC की जगह अभी BNSS, IPC, BSA and Evidence Act के अंदर the small act. इसके अंदर small act. There is a small act. There is a small act. Yes, yeah, Indian Evidence Act. So that you should know that here. So that is the conducting of a trial procedure. That is the conducting of the trial procedure, which is starting from Order 14 onwards, framing of the issues. 15 speaks of disposal of the case. 16 speaks of examining your witnesses in the matter. Then Order 18, under Order 18, the procedure is both, yes, the procedure is both uh, after examination, you tender, you argue the cases. Order 18 Rule 3 के अंदर, see that here? That deals with the right to begin first, then also begins here conclusion of the evidence, uh, conclusion of the evidence and filing of your written submission also is covered under Order 18 Rule 3. Please note that here. So this is the culmination of a trial proceeding before the court. Order 18 deals with it. Then order के बाद then once the trial proceedings are over, the court passes a decree. After arguments are over under Order 18, the court passes a judgment and decree that is dealt under Order 20. What kind of there are various types of decrees. आप देखेंगे. Yes, Order 20 से check कर लेंगे आप. The proceeding deal with all decrees, judgment and decrees. This all happens in a trial court. So the judgment and decree normally pronounced by the court immediately. The date is fixed here, and it should not be less than more than 30 days or 60 days time, beyond 60 days time. So everywhere endeavor has been made to see to it the judges also pass orders as expeditiously. But at the same time, the if the judge is unable to deliver, you cannot blame the judge. So यहाँ पे Order 20 deals with various types of decrees. I will tell you that here. Then they also mention the judgments of a judgment and decree of a small causes court under Order 20 Rule 4. What they should based on determination of final decision, contain a concise statement of a case, point of determination, decision, and reasoning for the decision. Sub clause 2 के अंदर. Then the what the decree should contain is under Order 20 Rule 6. Then various types of decrees the court passes in various suit. Number 1, you can take it here, partition decree. Partition decree is Order 20 Rule 6A. How the court passes is because no sooner a judgment is passed and a decree is passed as a lawyer for the plaintiff or defendant, you make an application for certified copies on the same day, because the judgment may go against you or may be in your favor. So you cannot execute the decree without a certified copy of the judgment and decree, and at the same time you cannot file an appeal without the certified copy of the judgment decree. See why? Because sometimes the judges may pass judgment and decree, pronounce it one day, and they deliver the copies after 60 days, at 70 days, maybe after 1 month, 6 months. But as a lawyer of the parties, either plaintiff or defendant, please make the application for certified copies on the same day or maximum next day. Today the judgment is given, you make it today or you make it next day tomorrow. उस दिन से अगर if you don't make it, the time begins to run against your client. Suppose the judge has passed the decree and judgment on 1st of August, and you made inquiries with the stenographer, such judgment is not signed, it will be, copy will be delivered maybe after 2 months, 3 months, that the judge is busy. So don't wait for 2 months, 3 months. Make application for certified copy immediately on the same day, next day, to take advantage of the Indian Limitation Act, that is a section 12 of the Limitation Act. Otherwise, the time begins to run against your client. That I will tell you the provision. Exclusion of legal proceedings, section 12. In computing the period of limitation in any suit appeal application, the day on which the said period is to be reckoned shall be excluded. So the day of the judgment is excluded. The next day is counted, because the appeals you are required to file under the CPC within 30 days. If the judgment copy is given to you after 60 days, you cannot say that my appeal file kiya appeal. So immediately file it, immediately keep it certified copy, so that you do not know whether judgment will go in your favor or against you. So for filing the appeal, you require a certified copy of the order and the judgment and decree. So the appeal, before going to the appeal court, suppose a court has passed an order against you, you are hereby called upon to quit, vacate, and hand over vacant possession. When a possession order is passed, the court may say to vacate the premises within a week's time, month's time, or immediately forthwith. As a lawyer, you should be alert with. And there's a provision in the CPC, the trial court itself can stay the decree before to enable to file the appeal. That provision you will find in under 41 Rule 5 में check करेंगे, where the trial court can stay its decree to enable you to file the appeal. Order 41 check करो दादा. Order 41 that deals with the appeals, memorandum of appeal. Rule 5, stay to be granted, stay by the court which passed the decree. See that order 41 Rule 5 can stay by the appellate court. So your appeal is not yet ready. So there's no question of asking the going appellate court. Now order 41 Rule 5 subclause 2 में check करें, stay by the court which passed the decree. Where an application is made for stay of execution or an appealable decree before the expiration of a time allowed for appealing therefrom, the court which passed the decree may, on a sufficient cause being shown, order execution to be stayed. No order for execution shall be stayed unless the court making satisfied that the substantial loss result may be caused, then application is without reasonable delay, the security has been given. You have to remember this provision, order 41 Rule 5 subclause 2, before the same court, because your appeal is not going to be ready immediately. You keep an application ready that this honorable court be pleased to stay the execution implementation of the order, as I am desirous of filing of the appeal in the matter. Because certified copy is not yet ready, your honorable court has been pleased to pass a decree decreeing the suit of the defendant. I am the defendant. So the suit is, I have been ordered to quit, vacate, hand over possession. That operative part may kindly be stayed for a period of 1 month to enable me to file the appeal. Please note that. ये remember करना, ये provision important है. especially when you are appearing for the defendant. So you should know what is the provision for filing an appeal in the Code of Civil Procedure Code. Yeah, in the Limitation Act, the appeals are given that here, yes. Article 114 deals with second appeal. We are not concerned. We are concerned with the first appeal. First appeal under the CPC. Article 116 under the Code of Civil Procedure Code to a High Court from the decree or order is 90 days from the date of a decree. Suppose this is from the district court से आप जा रहे हैं. Suppose Pune में district court has passed an order of eviction against you. You have 90 days from that date. Then any other court 30 days. Suppose if the order is passed in the City Civil Court Bombay, 11B कहता है कि the appeal period is 30 days. See, for district people, it is given more indulgent because they may be in a far city. In the cities like Bombay, or Calcutta, Madras, and Delhi, where the appeal court is your high court, your decree is passed by City Civil Court, or an appeal is passed by the decree is passed by the Court of Small Causes Court. The time to file appeal is 30 days. 117 check karo. From the decree or the order of a high court to the same court, 30 days. Suppose if the high court single judge has passed a decree in the latest patent under clause 12 of the latest patent, a single judge in the Bombay High Court trying a suit under ordinary original civil jurisdiction, he has ordered your eviction, branding you as a trespasser in a suit filed by the other side. Then you can file an intra appeal, that is a latest patent appeal under clause 15 of the latest patent, uske liye 30 days. So City of Bombay, Calcutta, Madras, where in the same court you are filing appeals are 30 days, but if your appeals are coming from a district court, which may be away from the main cities like Bombay, Calcutta, Madras, so unke liye 90 days time dega. So remember this, section 12 of the Limitation Act and article 116, and when the trial court normally grants a stay, but sometimes judges don't give it. A money decree cannot be stayed unless you deposit some money, 50% money. So the trial court itself has, because your memo of appeal is not ready as such. So order 41, rule 5, subclause 2, stay by the court which passed the decree. That means a trial court which passed the decree, you have a right to come. Okay. Then normally this is the provision. Then your appeal, first appeal provisions are under section 91. When I take the next session for the appeal, I will take section 91 first appeal, section 100 second appeal, then appeal to Supreme Court. I think last time we earlier dealt with the appeal from orders 104 and 43. I won't repeat them again. So we are dealing with execution matters. So when this is the procedure before the trial court, where the trial court itself has a power to grant a stay pending the hearing, pending the hearing and final disposal of the appeal. Because the appeal court, the trial court will not give you longer time. They may give you 30 days time because that is the limitation period. Then you have a right to file the appeal. File करने के बाद appeal, then you take out application under order 41, rule 5 CPC, then stay by the appellate court. Then you may tell the appellate court, the appeal has been filed today and the stay is, which was granted by the trial court, is being expired tomorrow. So this honorable court may kindly be pleased to stay the execution of the implementation of the trial court order. Otherwise, appeal will become infructuous. If the other side has filed a caveat under 148A CPC, then you are supposed to give a notice to them. Please note that. Other side will say that here, let no ex parte orders be passed, staying the execution, implementation of the order without notice to the caveator. So caveator is that we have discussed it, taking it while discussing section 148A CPC and order 20A के अंदर caveat का form भी है. So you have to give a notice to the other side that since you have filed a caveat, I am filed the appeal. I will be moving the Honorable Appellate Court for extension of the stay in the matter which please note. यहाँ तक हो गया. Okay. Then what are the various types of decrees which the trial court passes? I will just run you through. That is order 20 पे आ जाइए. Various types of decrees you will come to know. Various, because like earlier last time we learned the various types of suit from the schedule. Now यहाँ पे decrees सीखना जरूरी है तुमको. What are the order 20 जरा खोल लीजिए. Under order 20, that will tell you the various types of decrees which the trial court can pass. Yes, because the decree. Now let us see. I will start from here. Order 20, Rule 6A deal with preparation of a decree. That should be normally decree should be prepared and signed within a period of I think 15 days time. That is normally, but sometimes judges don't have time. There is no staff. It may take 1 month, 2 months. So this is a procedural proceeding. Then I'm coming. If a judge has vacated the office and gone, the subsequent judge, his successor can sign the decree. Then starting with the decree for immovable property, recovery of immovable, order 20, rule 9. What exactly decree, how it drawn? Order 20, rule 9. देख लीजिए आप. Decree for immovable property. This is a decree and not execution. Execution I will come later on. Decree for immovable property execution comes under order 21, rule 35. And 36 के अंदर removal of a tenant from the premises. 25. Abhi at the moment I am dealing with decree order 20, rule 9, immovable property. Then decree for movable property, order 20, rule 10. The decree is passed by the court because what you are challenging ultimately decree, not the judgment. Because the decree is the final order. Then decree may be, then decree for installment in a suit here. See order 20, rule 11 के अंदर. Then we discuss about the possession and mean profits. Section 2 के अंदर we discuss what is mean profit. When a occupation of a tenant or a licensee becomes unlawful after termination notice or after decree pass, then he has become possession illegal. He is not required to pay only the agreed rent, but he has to pay the market rent. So इसके लिए to determination of the market rent, that decree is under order 20, rule 12. 12C के अंदर the court can direct the institution of inquiry. Generally, I'm just giving you, go through and read it. Any difficulty you ask me. So decree for mean profits, order 20, rule 12. And the suit for specific performance which you file under section 10 of the Specific Relief Act, when your agreement of sale has been breached by the builder or agreement has been breached by the defendant, that suit is filed by you under the Specific Relief Act under section 10 of the Specific Relief Act. The court orders specific performance. Then decree is passed under order 20, rule 12A, decree for specific performance of contract for sale or lease of immovable property. Defendant agreed to sell you the property, he is backing out. Defendant agreed to lease out the property and he is backing out. So those provisions are there in the Specific Relief Act, section 10 से लेकर 16, 17, all relating to specific performance of a contract. The court passes a decree. Then you also heard of, I gave you examples of a suit for administration of a suit, that your grandfather left so many properties in Calcutta, Madras and Bombay, and I told you one suit is sufficient. With the leave of the court under clause 12 of the latest patent, and file one suit for administration of the property, suit for partition of the property. So in a suit for administration, the court make inquiries directing the defendant to give account, to give to find affidavit of various assets he is having of your father, grandfather, family property, of the partnership firm, give full details. So in a decree for administration, there's order 20, rule 13 के अंदर ये administration suit is a decree is passed. Then you have also heard of a decree for preemption suit on the Transfer of Property Act. So your neighbor is wanting to sell the property to strangers. You have a right to say that I am the immediate neighbor. I should be given preference to sale. योर हिंदू अनडिवाइडेड फैमिली, हिंदू अनडिवाइडेड फैमिली के अंदर the members of a HUF cannot sell their share to outsiders. It should be sold first. Preference should be given to the members of the family. So you have a right of preemption, a right to first purchase. Similarly, under the Islamic law, there is a rule: a Mohammedan cannot sell the property to outsiders. A preference should be given to immediately neighbor, family member. Now, even under the provisions of the Maharashtra Societies Act, you will find a provision in the bylaws. The member should not sell it to outsiders first. He must give a preference to the existing members. So it's called a preemption suit. Such a suit, in what manner decree is passed under Order 20, Rule 14. Please note that they are connected to the other substantive provision is Transfer of Property Act. Okay, please remember it. Then next is what kind of a decree? Order 20, Rule 15, decree in a suit for dissolution of partnership firm. See, under the Indian Partnership Act, two partners are carrying on business. There's a disagreement. The other partner alleging dishonesty, misappropriation, not giving account. So you will be compelled to file a suit for dissolution of a partnership suit, that the firm be dissolved and your share be given. So the decree will be drawn up under the provisions of Order 20, Rule 15. The judge has to draw a decree like this here. Then 16 में आ जाइए, decree in a suit for account between the principal and agent. Now in the Indian Contract Act, you learn the relationship of agency where the principal and agent. So if the agent is bound by the act of the principal is bound by the acts of the agent. If there's a disagreement between them, if the agent has committed fraud, or the principal is not paying him the amount which he agreed upon, then either of them can file a suit for rendition of account. I have rendered such a suit. A decree is passed under Order 20, Rule 16. Then 18 speaks of a decree in a partition property or a separate possession of shareholder. So you may take up the plea that here under the Hindu Succession Act, you have 1/3 property. You are entitled to share in your father's property, isn't it? So your brothers and uncles are not giving. So the property be partitioned and separate possession be given. I am entitled to 1/3, isn't it? So such a decree will be drawn up by the court. The property may be 10 acres of land. Your 1/3 acre, the may be partition. A separate possession be given to me. So under Order 20, Rule 18 के अंदर such a suit, the decree is passed. Then 19 decree when set off or a counterclaim is allowed. So we learned under Order 8, Rule 6 and 6A. 6 के अंदर आपने सीखा set off be allowed in a commercial suit, in a money suit, where the amount is a certain amount, the court can pass a set off. Or under Order 8, Rule 6, you have a counterclaim. So the court may dismiss the suit and allow the counterclaim. Then how the decree is to be drawn up is under Order 20, Rule 19. Now, mind you that this is hot. The court will ask you, you're filing a decree under what provision? This I'm challenging the decree which has been passed under Order 20, Rule 19 CPC. Then appeal relating to decree set off is 2 surplus 2. Then 20 mandate certified copies of judgment and decree to be furnished. Normally when you file, certified copies of judgment, certified copies are important. Without that, the court will not move. Even because decree is certified copies are useful to you for two purposes. Number one, for filing the appeal, and also for filing execution application under Order 21, Rule 11, Order 21, Rule 22. How these applications are filed under 2111, 2122, I will explain to you after this. Okay. The certified copies are mandatory. And I told you, on the day when judgment is delivered, on the same day you make application for certified copies. Don't wait. Otherwise, each day's delay you are to require to play, your client will suffer. Your client may not know all this. You as a young lawyer, you should make application immediately. Don't depend on your clerk. Check it properly whether your clerk has made application to the Registrar, High Court Bombay, Protonotary, High Court Bombay. Be pleased to furnish me certified copy of the judgment and decree and drawn up order. ये तीनों लिखे आप. Just don't say judgment. Please to grant me number one judgment Number one. Number two, decree. Number three, drawn up order. Drawn up order is not mandatory now. पहले mandatory था. तो ये सब लिखिए. Be pleased to furnish this on certified copies on payment of necessary charges which my client is ready and willing to pay. ये ले लीजिए आप. Okay. Then the next decree which I am dealing with you is Order 20 mein, these are the some of the decrees they have mentioned. The other provisions are incidental provisions. So these are the main provisions, Order 20 relating to decree. Decree and judgment. That is the learned trial judge. After hearing the argument of the party, passes a judgment. So the judgment hone ke baad, then the next move comes into play. Either file appeal. अगर अपील नहीं रहेगा तो अपील नहीं हुआ नहीं फाइल किया for some reason, then there will be execution proceeding. क्या बोलते हैं? Execution will be coming under the provisions of Order 21 onwards. It's a very lengthy topic, but you should know about it very well. Decree होने के बाद, then the next I will take it. The topic will be in the trial court. The execution. Execution is a very vast. I will take it subsequently because Order 21 के अंदर there are 106 rules. कितने? 116 rules here. This is one of the comprehensive procedure. Most complicated procedure is execution, because the Privy Council had said it here. In India, obtaining a decree is more easy than implementing a decree. Implementing decree is most difficult. The moment you go to execute a decree, then obstructions are created. Several rights are created. Multiple rights are created. And nobody wants to vacate the premises if a court passes a decree, and it takes a longer time. You have to take the police ka help. You have to appoint a court receiver in the matter. So anybody want to ask me any questions so far? This is the decrees. Okay. Now, before I take you to the topic of execution, which is vast, which I will take it later on, then further things. Yeah. Anything you want to? Yeah. Anybody has any question so far?
No, sir.
No? Yeah. Yes. Yeah. Then,
Hello.
yes,
Sir,
Pujya.
I have one doubt. Sir, actually, I am always confused when can I refer a judgment as a decree and when like both are interchangeable, or are there any major difference between decree and judgment?
You should go to the definitions of a judgment and decree, because section 2 के अंदर section 2 defines what is a decree, isn't it? Let's देख लीजिए decree का definition क्या है.
Yes, sir.
Decree and decree holder. Decree means the formal expression of a adjudication which, so far as regard the court expressing it, conclusively determine the right of a party with regard to all matters. So it is a final judgment which determines your legal rights. It's an order. Now the judgment, you said, what is the meaning of judgment? Section 2 में आ जाइए, 9 में. Judgment means statement given by a judge on the grounds of a decree or order. So decree or order is also a judgment. Now let us see what is an order. MNO. Order means formal expression of a decision of a civil court, which is not a decree. So order can be interlocutory order, an order appointing a receiver, an order of injunction. So they are all called interlocutory orders. क्या बोलते हैं? Order granting an injunction during the pendency of a suit. Order appointing a court receiver, order appointing a court commissioner. These are all orders. They are known as interlocutory orders passed during the pendency of a suit, and they are not final orders. then order of injunction is not a final order unless it is a unless it is a order passed under the specific relief act. Now, under order 39 CPC, we will be dealing with this immediately. After this, I'd like to take you this. What is it? Good question you raised me. So, decree means an order passed by the judge after recording the evidence of all the parties, after hearing all the parties. Final decision of a case is a decree. Yeah? Final decision. Whereas a judgment is nothing but a statement of a learned judge's opinion. That is not again a decree. But again, an order under section 2, which speaks of see that order का definition किसमें दिया गया है? 14. Order means a formal expression of any decision in a civil court, which is not a decree. So decree is after recording the evidence of both the parties, just gives a final finding. Yes, he has got a legal right. The plaintiff has proved that he is the owner of the property. The defendant has been proved to be a trespasser. That is the decree. Now order का example check करना आपको. Open order 39. Order 39 करो, open करो. You will come to know the temporary interlocutory orders. Order 39 खोलिए. There are certain interlocutory orders which are not decrees, which I am pointing out to you. First, starting with the order 39, which is very important to you from the examination point of view. Please remember this. Order 39. Yes. 39, rule 1 and 2. Open karo. You got it? 39, temporary injunction and interlocutory
Yes,
orders.
sir, yes.
Please note that
Yes.
these are not decrees. These are come in the category of orders. Or you may call them interlocutory orders. Now let us read this. Cases in which a temporary injunction may be granted. Now, under the specific relief act, mandatory injunction is granted, perpetual order injunction granted. So they are not temporary orders. They are final orders. Yeah. What is granted under section 37, 38, 39 of the specific relief act? They are perpetual orders in the nature of a decree. 37 can the temporary injunction. Specific relief act can the Sarah, give me that 39. Specific relief act speaks of temporary injunction. So order 39 speaks of a temporary specific relief act. See, wherein a suit which is provided by affidavit otherwise. Suit mean a plaint. So a plaint के अंदर this government must contain that a property in dispute is in danger of being wasted, damaged, alienated by a party wrongfully sold in execution or a decree. So the plaintiff will make a statement here. Number one, that your suit is for eviction of a defendant. The present suit is being filed for eviction of a defendant on the ground inter alia that he is a trespasser, he does not have a right title interest. Okay. Oh, ho gaya. Of course, that suit will not, the court will not decide the status of a tenant immediately. उसको बोलेंगे file written statement, उसको बोलेंगे you file rejoinder, reply, frame issues, interlocutory order. देखो कुछ हो गया. ये देखो शायरी, देखो कुछ हो गया इधर. I got it, touch something. Hello. Are you able to hear me?
Yeah, you got a call now.
Yeah, come now. हाँ, मैं बाद में बात करता हूँ आपको, मैं लेक्चर में हूँ. Yeah, specific relief act देखो लेक्चर में मिलेगा आपको. So in the plaint you are filing the present suit for a declaration that defendant is a rank trespasser. That is the main relief. Now That main relief will take longer time. You have to file written statement, evidence record होएगा, trial में जाएगा, issues frame होंगे, लंबा time. Suppose during the pendency of the suit, the defendant is trying to sell your property, or he is going to bring some outsiders in the property. So plain में लिखेंगे, the defendant who does not have a right title interest in the property is attempting to create third party interests. Hence, pending the hearing and final disposal of the suit, that this honorable court be pleased to appoint a court receiver, High Court Bombay, or in order of injunction restraining the defendant not to create third party interest. 39 में fit हो गया ये. 39 rule 1 में injunction मिल गया आपको. Number 2, that the defendant threatens intent to remove, dispose of the property with a view to fraudulent his creditors. Now यहाँ पे the injunction that the defendant is threatening to dispose of, alienate the property. ये pending the hearing and final disposal, ये injunction मिल गया आपको. Number 3, that the defendant threatened dispose of the plaintiff. ये भी आपको ये injunction मिल गया. Order 39 rule 1 में, rule 2 के अंदर injunction to restrain repetition continuance of a breach. So the defendant has committed breaches of a contract and further going to contract. Suppose you are a film producer, enter into a contract with an actor to perform for 10 shows. He is only performed for 5 shows and the remaining is not performing. You can seek an order of injunction against him. He should be directed not to accept assignment of other people, so that there will be a breach of contract. So that will be a temporary injunction again. Please note that here, this is a temporary injunction. Your suit may be for damages. Your suit may be for performing specific performance of a contract. You should complete the entire 10 shows or 20 shows as per the agreement. So pending the hearing and final disposal, he should be restrained from acting in any other, with any other producers or any other film. That is the injunction, order 39 rule 2. Then order 3 के अंदर the court has power to grant injunction directing notice to party, and proviso says if there is emergency in the matter, the court can grant ex parte injunction without notice to other side, returnable on particular dates. This is again an interlocutory order. Then now come to other orders. Under order 39 rule 4, injunction may be varied at discharge. Suppose with third party, if an injunction has been obtained against the adjoining owner in respect of his property, is affecting him, is not a party, he may come to the court. The order of injunction which has been obtained is really harsh. I am not concerned with the litigation. It is also covering my property. It may be varied. So you can say that the court, that's again interlocutory order can get. Then order 39 rule 7 can the detention, priversion, inspection subject matter. Now here you can also make a temporary injunction or interlocutory application telling the court, number 1, in the property which is in possession of the defendant, he is illegally constructing some floors which he cannot do. He should be restrained by an order of injunction. Now, to ascertain the position, whether it's constructing or not, the court may kindly appoint some commissioner, some architect. That is, see, that provision is there. Clause B can then, for all purposes, authorize any person enter into land so and so, any other party. For all purposes, authorize any samples to be taken. So, court ko full power hai. This is again an interlocutory order, pending the hearing and final disposal. Then another order the court may pass is here. If it is a money suit, the court you may say that defendant is staying free of charge. He is not even paying taxes. I am paying from out of pocket. He should be directed to deposit money in the court at the market rate or at the original rate which was paying. So this is again interlocutory. This is without prejudice to the rights and contention part. So again in interlocutory order. Then another interlocutory example I'm giving you. Order 40 check करो आप. Court may appoint a court receiver. Order 40, appointment of a receiver. Receiver is actually a custodio legis. The property will be handed over to the court itself. See, where it appears to the court to be just and convenient, the court may, by order, appoint a receiver of the property, whether before or after decree. Before decree is with a view to stop the damage. After the decree is for enforcement of a decree. That despite the court having passed the order, he is not vacating, please appoint a receiver to take possession. So these are all interlocutory orders. Now, iske alawa, what are the other interlocutory orders? Section 94 kholiye aap. Please, when the question may ask you what are the interlocutory orders, 94 खोल लीजिए. Yeah, supplemental proceeding, have you got it? Section 94 मिला आपको?
Yes, sir.
Yes, please, these are also interlocutory orders. Now see, it says, in order to prevent the ends of justice from being defeated, the court may, if so prescribe, number one, issue a warrant of arrest to defendant to bring him before the court to show the cause why he should not give security for appearance and he fails to comply with the security. So you may have filed a suit that he owes me 10 crores. He is running away to America. And he should be brought back to city to give security to me. The property, I have made the application for attachment of the property. The defendant is running away. He should be directed to give security. That's the interlocutory order again. B, directing the defendant to furnish security to produce any property belonging to him and place the same disposal, current so and so, attachment before the court. So the court, you may say that here the suit is filed for partition of the property. Suit is filed for the mortgage suit under order 34 for redeeming the mortgage. The defendant is running away. He is not cooperating that the property be attached. He should be directed to come before the court for the purpose of giving security. The amount which he has taken is amount of rupees 10 crores or 5 crores. He should be directed to deposit the money. It's interlocutory order. C, grant a temporary injunction in cases of disobedience, commit the person to guilty, so and so. यहाँ पे कोर्ट को पावर है, grant an order of injunction restraining the defendant from committing any act, or if there is a injunction already granted, he should be committed to civil prison for non-compliance. This is also interlocutory order for a execution. Number D, appoint a receiver of any property enforcing performance of a duty to attaching the selling the property. So the defendant in a suit is not performing particular act. He is not obeying the order of injunction. You may say that let the receiver be take over possession. And I have filed a suit for partition, and he is collecting rent from the various tenants and occupants without depositing in the court. What will happen to my share? He will take and run away. So let the court receiver be appointed under the provisions of Order 40 Rule 1 under 94E for the purpose of collection of the amount that money should be deposited in the court or money be invested in the court. Sanjay, these are interlocutory order. E, make such other interlocutory order as it may appear to be just and proper. So the court ko full power hai during the pendency of a suit to regulate the suit correctly. The court can pass any order which is the court feels it is absolutely necessary in the interest of justice to secure to pass the order. So these are all interlocutory order. When you open the specific relief act, I will explain to you the difference between a final order and an interlocutory order. Now, under the provisions of the Specific Relief Act, Part 3, Section 36 onward dealing with injunction. Now, the number one is a preventive relief granted. Preventive relief is granted at the discretion of the court by injunction, temporary or a perpetual. Temporary injunction will come under Order 39, also 36. Temporary means pending the hearing and final disposal of the suit, defendant is restrained not to create third party interest. Perpetual injunction means that the defendant does not have any right, title, interest in the property at all. He is permanently restrained by a perpetual order of injunction from selling, disposing of the property. There's a difference between perpetual order is a decree, whereas temporary injunction is an interlocutory order. Okay. Now please come to 37. Temporary and perpetual injunction. Temporary injunctions are such to continue till a specified time, mean till the disposal of a suit for a period of 1 month, 6 months, 7 months, 1 year, or until further orders, or the order, and may be granted at any stage and are regulated by the CPC. Order 39, Rule 1 and 2 CPC. Abhi padhe humne. Order 39 is dealing with interlocutory order. 37 also deal. Then number 2, a perpetual injunction can only be granted by decree. See that perpetual final order. It's a final order, perpetual injunction. That this order be pleased to declare that he does not have a legal right, title, interest. An injunction be granted, permanent injunction, restraining him to dispose of the property. ये decree हो गया आपका. Okay. Similarly,
Yes,
13.
sir.
Yeah. समझ में आ गया अभी?
Yes, sir. Thank you, sir.
Yes, that is a. So you learned the perpetual injunctions, the decree, the interlocutory injunction. What is an order? That is the difference between order and anything. Any और कुछ पूछना है क्या आप लोग को? Or shall we continue further? Shall we continue further or stop it? Are you getting bored?
No, sir, we can continue.
We can continue. Or we'll continue for another sometime. One more topic will ले लेंगे हम लोग. So interlocutory order. So another, some of the interlocutory orders where the court passes are important. Open section 75. Should know all this. Section 75 में देखिए, power to issue commissions subject to the condition and limitation. Court may issue commission to examine a person. Under Order 18, Rule 4 CPC, you have to file your examination chief. And you are an old man, sick person, confined to bed, cannot come. You may tell the court, please appoint some commissioner, an advocate, junior advocate, court officer. So he will be appointed. A commissioner, court commissioner appointed. Number 2, to make local investigation. So the property which is in the hands of the defendant is trying to damage. He is constructing illegally one more floor without the permission of the owner, landlord, without the permission of the municipal corporation. आपको कोर्ट को क्या बोलेंगे? Please appoint a commissioner. An architect may be appointed to come and see the premises and submit the report. Interlocutory order हो गया अभी. Then examine or adjust account. So यहाँ पे भी when a partnership dispute is pending or rendition of account is not going on, the court may say that I am appointing a court commissioner examiner to examine the accounts. Then to make a partition, preliminary decree can be passed in a partition suit even before the final decree. There are 10-15 properties, or a suit for mortgages under Order 34. Court can immediately pass a partition. Appoint a commissioner, direct the collector Bombay to make a partition. To hold a scientific technical expert investigation. Now, this is also there under Order 39, Rule 7, scientific technical expert investigation. So you may have filed a suit against the hospital for not conducting post-mortem properly. the deceased has gone. You're claiming damages for mental torture, agony, for botching up the operation. You appoint an expert to investigate it. That kind of a suit. Then to conclude the sale of the property, which is the subject matter of speedy, natural, so and so. तो यहाँ पे भी court can appoint a commissioner, person, any other ministerial act. So order 70, section 75 हो गया, interlocutory orders. पहले हमने पढ़े order 39 से लेकर 1 to 10, isn't it? Then the provisions of specific relief act section 37, 39. Now open order 26 CPC के अंदर against interlocutory order क्या होते हैं? Order 26. Yeah, order 26 commissions. This is to be read along with section 75. Cases in which the court may issue commissions. Any court may in any suit issue a commission for examining on interrogatories. Otherwise, any person resident within the local limits of jurisdiction who is exempted from the court, who cannot appear. Number 1, order of commission. 2, then 3 के अंदर where witnesses reside within the local limits of jurisdiction, you can make application to the court for examination. How the commissioner issued order 4. Number 5, commission request to examine witnesses within India. Then deposition of the witnesses. So entire order 26 deal with appointment of various types of commission for performing various acts. Ministerial act, sale of immovable property, commission to examine adjust account, order 26 rule 11, commissioner to necessary instrument, report devices, and to make partition procedure. Please note that these are all interlocutory orders. These orders are passed pending the hearing and final disposal of the suit. Order 39, section 75, section 94, and order 26. These are all interlocutory orders. When you are asked to give what are the interlocutory orders, you have to know this. Okay. These are the various interlocutory orders. Now, yes. Then I will briefly touch upon the topic of execution before filing the appeal. That is order 21. Just I will touch today 2 topics. Order 21, rule 11, 22. उसके बाद में stop करेंगे. Then we'll deal with the entire execution procedure. How होता है इधर. Now open order 21. Order 21 से पहले आपको चेक करना पड़ेगा section 51. What are the modes of execution? Open section 51. When a decree, the court has passed a decree, when a decree is sought to be executed, what are the various modes of execution? Is given under section 51, if I am not mistaken. Yes. Yeah. Procedure in execution. Procedure in execution, how it starts when a decree is ready. You are a decree holder. I am a judgment debtor. Defendant, I am a judgment debtor. A plaintiff who holds a decree is called a decree holder. He is entitled to execute a decree against the judgment debtor and all person claiming through the judgment debtor. Now, उसके लिए you will have to fill up application forms under order 21, rule 11. 21 खोलिए. I will briefly discuss today. Then I will stop this. You come to know the order 21 खोल लीजिए. This is a very cumbersome and lengthy topic, but very interesting. Yes, order 21. Have you been able to open it?
Yes, sir.
Yes, ये order 21 शुरू होता है. Order 21, yes. Yes. Execution of decrees and orders. So it is not only decrees and also certain mandatory orders. You know, under order 39, rule 1 and 2, the court can also give a mandatory order of injunction. See, under the Hindu Marriage Act, section 24-25 के अंदर, the court is giving pendant delight maintenance to a Hindu woman. All of you know that here. So that is the suit is pending for a decree for dissolution of a marriage or for restitution of a conjugal right. Suit is pending. During the pending, the wife or husband takes out application under 24. 24 is an interlocutory order. The court is awarding the husband to deposit every month, pay the amount of rupees 25,000 to the wife. He is not doing that. So you can go in execution of this order. So decree means a court has passed a decree against a tenant to quit, vacate, hand over possession. He is not vacating it. Now, these provisions will come into play. Order 21. See, what are the decrees? The money decree. Order 21, rule 1 is dealing with money decree. So you file a summary suit. The court ordered that defendant has no defense. He is bound and the decree has been passed directing the defendant to pay the amount of as demanded in the decree along with interest of 6%. The decree, how it is to be executed, deposit in the money के अंदर, court के अंदर ये reason दिया गया है. 2 के अंदर, that is all discussion on the various decrees and how this decree, what application you are required to make, that I would like to take under order 21, rule 11 में आ जाइए. There's a format for that. There's a oral application. Normally in money decree, orals कोई नहीं करता. You have to make written application. Order 11, order 21, rule 11 applies to written application. See, the written application to include number 1, name of the suit, name of the parties, decree, appeal from, whether appeal हुआ है नहीं हुआ. Normally appeal होएगा तो you cannot take out execution application. Please note that. Is a stay granted by the appellate court? No decree can be taken. Suppose appellate court की normally application for execution should be filed within 12 years. अगर appeal court में appeal pending है 15 साल से, does it mean that your application is barred? No. The stay which has been covered by the appellate court is excluded. यहाँ पे details of amount particulars देंगे आप. देखिए यहाँ पे एक appendix में form आता है application. Under subrule 2 may require application to produce the certified copy of the decree. Read this very clearly. This is a form which should be filed and executed within 2 years' time. 2 years' time. अगर 2 years में करेंगे आप, notice is not given to other side. The court बोलेगी other side participate in the trial court, they should vacate the premises or hand over the decree and pay the money. तो यहाँ पे ये फॉर्म भरने के बाद आप टैबुलर फॉर्म आता है, there's a tabular form execution का, which you open and see tabular form. Can you see where will you find it? Order 21 में check करो. There's a tabular form. Anybody is able to lay their hand? Please go in Appendix A. The tabular form भरना पड़ेगा आपको execution के लिए. I will lay my hand. You also try to lay it here. Now this application under Order 21, Rule 12, Rule 11 to be invoked, should be filed within 2 years में file करेंगे आप. Then other side को notice देने की जरूरत नहीं. But the time the decree should be executed within 12 years. After 2 years के बाद, then the form which you use it under Order 21, Rule 22. Order 21, Rule 22. Notice to issue cause against execution in certain cases. Where an application in execution is made more than 2 years. देखो 2 years क्या मिलेगा? After 2 years के बाद 21-22 after the due date of the decree. So 21-11 के अंदर you should make the application within 2 years. And no notice will be required to be issued. The court normally doesn't issue notice under 21-11. But 21-22 after 2 years के बाद against the legal representatives, because the judgment the debtor must have expired. The decree is sought to be executed against his children. Then against assignees, he must have sold the property to XYZ. Then in that event, the court is required to give notice to the other party as to why the decree should not be executed. The defendant died, leaving behind his widow and children. Look here, after the decree, they died. So the decree holder has to bring them on record. Please note that you have to amend the decree that the defendant, the judgment debtor died during the pendency of his suit, leaving behind the following heirs. So an application is being filed under Order 21, Rule 22 for execution. Now, for example, you are trying to evict them from the premises. If it is a decree for immovable property, that application, appropriate application will be Order 21, Rule 35. So decree for immovable property. How you take possession. Then if it's a decree for specific performance, Order 21, Rule 32. Please note that here. ये सब चीजें ध्यान में रखिए आप. So each provision has got a separate identity here. Then a decree for delivery of immovable property when occupancy in tenant, Order 21, Rule 36. So you should know this. The court may ask you under what provision the application is being filed here. So there are various provisions, and now this is somewhat here. Then the basic remedies which are available to an execution, that will be explained by Section 51. ये 51 लेके मैं स्टॉप करता हूँ आज. Section 51 ले लीजिए आप. The modes of execution of a decree. See the power of the court to enforce execution. Number 1, subject to such condition and limitation as the case may prescribe, the application for decree and order. Number 1, by delivery of property by a specified decree. But delivery of property, that application will come under 21, Order 21, Rule 35 and 36. Deliver karo property, immovable property. B, by attaching and selling the sale without attachment of any property. So the court has power to attach the properties. There is a power to attachment of the properties because the defendant is not vacating the properties. The third mode of it is arrest and detention of the person. So if the defendant is not vacating the premises or not paying the money as per the decree, you have a right to get him arrested too. Then arrest and detention के बाद number 4 is appointment of receiver. See, receiver is the custodial legis. Any officer of the court can throw anybody out. So this is the orders which are passed in execution. Such other manner as the case may be grant require it. These are all final orders which may be in execution of the decree the court passes the order. So when ultimately when a court passes a decree, the order 20 सीख गया आपने various types of decrees. Then execution procedure apply करने के लिए order 21 rule 11 में application किया आपने, isn't it? That application should be filed. If it is filed within 2 years, then no need to give notice to other side. But if it is filed after 2 years and within 12 years, then you have to give notice under order 21 rule 22 notice to other side. Then I'm just first dealing with the 2 types of decree, and the decree is passed for a immovable property, directing the defendant to quit vacate. That will come order 21 rule 35. And a decree for eviction of a tenant will come order 21 rule 36 के अंदर. Then various other decrees I will deal next time here. अभी आज के लिए इतना stop करेंगे, isn't it? I don't want to bore you too much. Anybody wants to ask any question so far? कुछ पूछना है?
Ending वाला है.
Huh?
I guess they don't have any doubts.
No,
Don't have? नहीं ना?
No, sir.
Yeah. So we will stop it. We will take up tomorrow, day after tomorrow lecture. We'll inform you accordingly.
Okay, sir.
We'll continue further. Any further topic you want specially, please notify to me earlier. I'm going as per the how the CPC works in the court of law. उसी तरह से कर रहा हूँ. Execution अगर नहीं होगा अपील करने का तो वो provision लेंगे हमने. So the most important provisions in execution order 11, order 21 rule 11, order 21 rule 22, 21, 35, 36 लिया मैं. Then sometime an obstruction is caused, third party rights are created. How to remove them, I'll find out to you this. Okay, कोई सवाल पूछना है किसी को?
No, sir.
Okay, bye bye. All the best.
Thank you, sir.
Thank you,
so
sir.
much.
Take care. All the best.